I'd like to at this time reconvene the Lane County Board of Commissioners for this Tuesday, December the 13th. We have 4 public works items regarding Florence and public hearings respectfully with those items. And then we have item 2 is deliberations on the ordinance 1343, which is the proposed quarry site. So with that, we'll get started with the Florence items. I'll read all 4 of them into the record first, and then read the script, and then have a public hearing. So the first one is second reading and public hearing ordinance number PA 1334 in the matter of co-adopting amendments to the Florence Revitalization 2020 Comprehensive Plan, Coastal Goals, and Lane County zoning maps as applicable within the urban growth boundary outside Florence city limits, and adopting savings and severability clauses, file number 509-PA16-05276, Florence Periodic Review Work Task number 6. The next item is ordinance 16-11 in the matter of adopting amendments to Chapter 10 of Lane Code and adopting savings and severability clauses, file number 509-PA16-05276. Next is ordinance number PA 1335 in the matter of co-adopting amendments to the Florence Revitalization 2020 Comprehensive Plan, Parks and Recreation Policies, and the Florence Comprehensive Plan Map, and adopting savings and severability clauses, file number 509-PA16-05277. And finally, ordinance number PA 1336 in the matter of co-adopting amendments to the Florence Revitalization 2020 Comprehensive Plan and Florence Stormwater Management Plan, various housekeeping amendments, and adopting savings and severability clauses for file number 509 PA 16-05276. We have with us today our senior planner, Lindsay Eichner. Before us here's the purpose. The decision of the board is subject to establishing findings of fact showing compliance with the applicable comp plan policies and lane code criteria cited in the staff report. Evidence and testimony should be directed toward the approval criteria. Testimony not directed toward the approval criteria may be irrelevant to this land use proceeding. People wishing to testify must wait to receive recognition from the chair and state their full name and resident address. Disruptive conduct such as applause or cheering may cause for postponement or continuation of the public hearing. So announcing the opportunities for submission of information and appeal. This is the opportunity for those present to enter information into the record, verbal or written. Written materials related to the application submitted prior to or during the public hearing and not rejected by the board are considered to be part of the record. Failure to raise an issue to enable a response may preclude appeal to LUBA on that issue. Only persons who qualify as party may appeal the decision of the Board of Commissioners to LUBA. So with that, I'd like Lindsay, the staff report.
Good afternoon, Chair Stewart and Commissioners. The City of Florence has made application for co-adoption for 3 plan amendments to their comprehensive plan. One of the plan amendments also has triggered amendments to Lane Code Chapter 10, so that's why there's 4 ordinances before you today. All 3 of the proposed amendments to the comprehensive plan have already been through the city's planning commission process and their city council and were adopted between 2009 and 2011. The proposed amendments to Lane Code Chapter 10 are to the following sections: the definitions section, the estuary zones, shorelands combining zones, and the beaches and dunes combining zone. So Lane Code Chapter 10.020, and then sections Lane Code Chapter 10.225 through 270. with the addition of a special development standards section, which is proposed to be Lane Code Chapter 10.261. The Lane County Planning Commission held a public hearing in the city of Florence at City Hall to encourage participation in the process. That meeting was held on the evening of October 18th, where the Planning Commission concluded their public hearing and forwarded a recommendation for consideration for the board with approvals for all of the proposed amendments. They also wanted to specifically request direction from the board to formally recognize previously approved home sites through previously approved subdivisions where home sites are considered when reviewing the coastal overlay zones. And staff in the city also support that recommendation. In the agenda cover memo, I had talked about this a little bit. We reviewed how to propose this to the board with legal counsel and determined that it was not necessary to codify this due to the fact that those previous approvals don't have expiration dates. And so we can continue to recognize them. The planning director can continue to recognize those approvals because they don't expire. So that was the determination that we concluded. The one instance where that wouldn't be true is if there'd been significant changes to a property, say that there's a landslide and that was brought to our attention, then we would want to re-review the property for potential hazards during development. So that would have to be brought to our attention. And that is our current practice right now, and we foresee that continuing to be our current practice or our future practice as well. All of the approval criteria for all four ordinances are listed in the agenda cover memo. I'm happy to discuss them if you have questions, but I'm not going to go into the detail right now. The findings are attached to each of the ordinance in the packet and have been reviewed by staff and legal counsel and have been found to address all of the applicable approval criteria to our satisfaction. I've distributed 2 additional comments that we've received from the public since we've sent out the agenda cover memo, and they're before you today. One of them requests that the record be left open, and staff would suggest or would support that request, that the record be left open for 1 week and that we continue deliberations to January 10th, 2017 at 1:30 p.m. The city is going to make a presentation on the 3 main proposals to give you some background of where these projects came from. And I'm available for any questions on the proposal that you have. Thank you.
Okay. Any questions before Florence staff? All right. So this time.
Good afternoon, Commissioners. My name is Sandra Belson, and I was the Community Development Director for the City of Florence when these amendments had been approved by the City of Florence. And at this point, I am working on contract for the City of Florence to take these through your co-adoption process so that these comprehensive plan policies would apply in the area between the city limits and the urban growth boundary. So as Lindsay had said, there are 3 proposals before you. The most significant in terms of having an impact onto the property owners who own that land between the city limits and the urban growth boundary is with the coastal goals. And so that's the bulk of my presentation, and then I will just touch a little bit on the other 2 proposals. As Lindsay said, your co-adoption of these coastal goal amendments would complete periodic review after having been in periodic review for 20 years, so we're looking forward to that as well. So the objectives of this project are not only to complete periodic review, but to make the comprehensive plan and the implementing ordinances, so that's your lane code, consistent with statewide planning goals 16, 17, and 18. So, and I'll go into that in a little bit more detail in the following slides. We hope that you would co-adopt these coastal elements, and as well as the zoning code and zoning map amendments that would implement these policies. There's also an opportunity to incorporate the Shelter Cove Land Use Board of Appeals decision, which dates back a number of years. So in developing the policies to comply with the statewide planning goals, there was a lot of coordination with Lane County and then the state and federal agencies, including the National Marine Fisheries Service, the Bureau of Land Management, Sayusla National Forest, U.S. Army Corps of Engineers, the Confederated Tribes of the Coos, Lower Umpqua, and Sayusla Indians, and then at the state level with the Department of Land Conservation and Development, the Department of State Lands, Department of Fish and Wildlife, and the Department of Environmental Quality. We also coordinated with the Port of Sayusla. So there are a lot of complicated elements to these coastal goals, so we wanted to make sure that we got real expertise in terms of understanding how they would apply to development in the Florence area. So there is an update to chapters 16, 17, and 18, and in Florence, the comprehensive plan chapters mirror the statewide planning goals. So those chapters 16, 17, and 18 are also the same as the statewide planning goals for coastal resources. There were other amendments that we also made to chapters 5, 7, and 14 to make sure that there's consistency throughout the comprehensive plan. As I mentioned before, there are corresponding amendments to lane code and the lane zoning maps. So as we undertook this effort, as I mentioned before, we needed to comply with statewide planning goals, and the county previously had a coastal resources management plan. That's the CRMP. So the county's coastal resources management plan, we found when we started, we were going to use that within the urban growth boundary, but we were finding that there were some inconsistencies with state law, some areas where it didn't really match up with our community needs. So what we ended up doing was actually no longer relying on the Lane County Coastal Resources Management Plan. So that is not applicable inside the urban growth boundary, although we still continue to rely on the Lane County inventory. That was the basis, the factual basis for these planning efforts. So the factual basis is the same, the policy level is different. So from that, those policies that are originated from that Coastal Resources Management Plan, we incorporated many of them into the comprehensive plan directly, but not wholesale. And then from that, looked at the code amendments that needed to be made to implement those policies that are therefore in compliance with the statewide planning goals. So to touch on each of these individually, statewide planning goal 16 has to do with the estuarine resources. So the estuary applies to the edge or to the banks of the estuary, and there's basically zoning that applies to the water. So you don't always think of water being zoned, but the estuaries actually have zoning districts. So those estuaries are zoned in accordance to the development that can occur within that estuary. So those zoning districts correspond to management units. So those management uses are based on the Lane County Coastal Resources Inventory, which is the adopted inventory within the Florence urban growth boundary. And then there's those management units are classified as natural, conservation, or development based on the amount of development or the resource value of those different areas. And so the management units in the comprehensive plan are generally the same as those in the Coastal Resources Management Plan. And so these are implemented outside the city limits, inside the urban growth boundary, through Lane County's natural estuary zone and then the conservation estuary zone. Moving on to statewide planning goal 17, which are the coastal shorelands. These coastal shorelands apply to all lands contiguous with the ocean, the Siuslaw Estuary, and then the lakes. So we have Munsell Lake, North Jetty Lake, Heceta Junction Lake, South Heceta Junction, and then the seasonal lakes. So again, the approach to this is with management units, which then correspond to the combining zones that Lane County uses. So there are natural resource conservation management units, mixed development, which is only within the city, residential development, prime wildlife area, and then the dredged material disposal sites. So within the comprehensive plan, we have policies regarding these coastal shorelands that apply to each of these different management units. The comprehensive plan also identifies the water-dependent sites and those dredged material disposal sites, which come directly from the county's dredged materials disposal plan. So then these are the combining zones that implement those management unit policies from the comprehensive plan. So again, these are these combining zones, or sometimes people think of them as overlay zones. Finally, there's the statewide planning goal 18, beaches and dunes. So this is probably the biggest difference between what the city has in policies compared to the county. So the statewide planning goal designates that the areas covered by beaches and dunes are along or adjacent to the coast. So these include the beaches, the active dune forms, recently stabilized dune forms, and the older stabilized dune forms and inner dune forms. So per state law, permits for beachfront protective structures can only be issued if the development pre-exists 1977. Also, those 4 dunes can only be breached in very certain circumstances, which I've listed there. So pretty restrictive on what you can do within that beaches and dunes district. So the county has, through your zoning, has basically covered all of the city of Florence with this beaches and dunes combining zone. So if you can see, that darker stippled area covers almost the entire city limits. What we did in Florence was, instead of having that beaches and dunes combining zone cover the entire city, we limited it to that very small area, which is basically the deflation plain on the north side of the Siuslaw River as it goes out to the ocean there. So what that does is really limit the application of those policies to that smaller area. What the county does to implement that bigger overlay zone is require site investigation reports. So if there's property that's developed, there's a site investigation report required. So what Florence has done instead was base that need for a site investigation report not on a broad swath of beaches and dunes combining district, but rather on the soils types. So if there are soils that are steep slope or hydric soils, such as like your wetland areas or dunal areas, based on the Natural Resources Conservation Service soils map, then you would be required to have a site investigation report. But if your area is not one of those soils that would indicate a need for additional study or additional engineering involved in the development, or special soil erosion controls through vegetation, if you don't need any of that special development considerations, then you do not need to go through a site investigation report process. So that really is the biggest difference between what you've had in the past and what is being proposed as part of this package of code and comprehensive plan amendments. So it limits the need for these site investigation reports through the application of these special development standards. And then we also, with Florence, with these amendments, there's two different levels of site investigation report. There's the phase 1 and a phase 2, which a phase 1 can be done fairly simply. The phase 2 is when you really need that qualified engineer or hydrogeologist or whatever to come in and look at the site-specific condition. So that concludes the part about coastal resources. I can continue with the next two unless you had any questions before I move on.
Any questions? Nope.
Okay, seeing none, move on to parks.
Just, actually, Sandra, just a process check. This is part of the staff presentation, or is this the city's?
I guess this is technically part of the city's presentation.
Presentation? Well, then I better open the public hearing
Okay.
and show that that first presentation was included in the public hearing. Does that matter, Andy?
Yeah, I wasn't sure myself. Yeah, may as well do that and incorporate Sandra's initial discussion into the hearing portion of it.
Okay.
I think it all is going to come into the record and be the basis of your decision if as needed. So it's not crucial, but you may as well do it to make sure it's all consistent.
Okay. So at this time, I'll open the public hearing and ask that that information that you just presented be incorporated in it. Thank you. Now proceed.
Okay. So the second item before you, it has to do with the Florence Parks and Recreation Master Plan. So the city developed a master plan that went before the city for endorsement, and that became the basis for the comprehensive plan amendments. So the city amended the comprehensive plan text and map to be consistent with the City of Florence Parks and Recreation Master Plan. So there are some county-owned parks within Florence's urban growth boundary. Those include 3 Mile Prairie, Ocean Woods, Heceta Beach Access, which is just north of Driftwood Shores, the Munsell Lake Boat Launch, and Harbor Vista Campground. There are no zoning or code amendments needed to implement the policies and maps for the Parks and Recreation amendments that Florence adopted. The county zoning already is zoned appropriately for all of these parks. The comprehensive plan designations are, some of them are changing to match that county zoning. But it's basically just a policy level. There's no implementation in terms of code or zoning map amendments needed. So the last item before you is largely about public facilities, specifically stormwater has the most part of this. And these amendments came out of the Sayusla Estuary Partnership, which was an integrated multiple objective approach to watershed protection and restoration. So this partnership included, was a broad effort that included elected officials and community stakeholders to protect and improve the water quality and fish and wildlife habitat in the lower Sayusla watershed. So there were guiding principles that came out of this partnership, and these principles were endorsed by the City of Florence, Lane County, Heceta Water District, the Sayusla Soil and Water Conservation District, the Sayusla Watershed Council, and then the Confederated Tribes of the Coos, Lower Umpqua, and Sayusla Indians. So these comprehensive plan amendments were to be consistent with those guiding principles that came out of the Sayusla Estuary Partnership, and then also to include only the minimum requirements per state law of what needed to be in our public facility plan provisions of Goal 11 for public facilities and services. And I'll explain that a little bit more. So in the past, Florence would adopt wholesale these various utility plans, like the Stormwater Master Plan or the Water System Master Plan, but not all of those plans actually need to be part of the comprehensive plan. So it made actually amending those plans more cumbersome than it needed to be, or more inclusive than they needed to be. So what these amendments did was restrict what's in the comprehensive plan to the minimum that's required by state law, so that other amendments don't need to be comprehensive plan amendments. So we incorporated the 2011 Water Master Plan update, and we included the county's coordinated population projections, and then took the opportunity to update some public safety provisions. So in terms of stormwater management, the county had already co-adopted our stormwater management plan. So now as we make changes to that, you also need to co-adopt those changes. So Florence removed the best management practices from the plan. So we took those best management practices out of the stormwater management plan and put them into code. So now the city code references what the city adopted as the Florence Stormwater Design Manual. That's not here before the county to approve, because that's how we implement it, but that's not what we are asking the county to adopt in terms of your code requirements. So all we're asking for you to adopt are the policy level, but not anything to do with implementing the code in terms of your zoning code requirements. So that concludes presentation, and I'm happy to answer any questions now or at the end of the hearing.
Okay. Would you have any questions for Florence? Okay. Not at this time. So looking to staff, or is there anyone signed up at all? Okay. So we start out with folks that are testifying in favor. And I'm not sure, we only have one person signed up, so we'll just go to that person. Pat Bradshaw, if you could come forward and restate your name and that you're from Florence, and then I'll start the 3-minute timer.
Okay, actually, I'm Pat Bradshaw. I live at 2410 East Irwin Way in Eugene,
okay.
But I do have property at 88088 Woodlands in Florence. And I'm going to build a little piece of little cabin down there someday. So the reason I'm here, all the work they've done is great. My little half acre that I have down there, the soils map that they showed, the real colorful one, the phase 1 audits or whatever is based on the soil type. This is very self-serving. My half acre, the line goes right through the middle of it. So a little bigger than this. If I decide to build over here, I have to have this survey and investigation on my property. If I build over on this side of it, I don't have to. If you read the real fine print on the map, it talks about the fluctuation in the size because of scale that it was done at. So what my hope here is there's a handful of us out there whose property is split with these new lines, and that we'd get some leniency and not have to do the investigations on those properties. So that's what I have.
Okay. Thank you. Is there anyone else that would like to speak to the Florence ordinances? Okay. Then I'd look to Florence staff. Any rebuttal? Comments that were brought up?
I think what would be best is to be able to respond to him, as well as the written testimony that you had received in a written fashion, so that we have a chance to collaborate amongst county and city staff together to be able to best determine how to address his particular issue.
Okay. Is there anything else you'd like to add then?
I mean, I hope that if there are any questions that come up, that we're able to address those so that we can get them adopted soon. But I do think that working with county staff to figure out, since this will be a different process rather than just automatically having the site investigation for every property, working out these details about how it applies to past decisions and how it would apply to situations like this going forward, that we need to make sure that we can come up with a solution that works with how your county staff is going to process these.
Okay. I got Commissioner Bozovich and Commissioner Farr.
So a quick question for you, Sandra. As I'm reading things, as it stands today, Mr. Bradshaw's property would have to go through site investigation because that applies for the entire city of Florence with the overlay right now.
Yes.
But if we approve this, at least he'll have the ability to develop part of his property without an investigation. It's just a matter of where he chooses to site his house, his cabin or whatever.
Correct.
So it's at least eliminating a major portion of the city of Florence from the site investigation. And I just, a quick comment, it's great to see some of these things coming forward after so many years, having participated on this Iusaw Estuary Partnership, elected officials, stakeholders, that all the aquifer protection that's built into some of these changes is really important because that's a sole source aquifer for the city of Florence and the Heceta Beach, the Heceta Public Utility District. I keep wanting to call it Water District, but.
Right. Well, they were a water district when they endorsed the principles, but now they're different.
Yep.
Okay. Commissioner Farr.
Thank you. Just a question regarding Mr. Bradshaw's testimony. And for the record, Mr. Bradshaw, when I was a city councilor, he was my council. He's in my district. As a county commissioner, he lives in the same house. He's not in my district. So he actually is in Commissioner Bozovich's district. But regarding something that Mr. Bradshaw mentioned that I'm curious about, the ambiguity that's presented by the scale of the original map. Am I hearing that correctly? That because of the scale, there's a certain amount of inaccuracy potentially built into the lines that were drawn.
I think that's fair to say, and I think that we haven't discussed. I have not had a chance to discuss his comment with Lindsay, your staff, but I would say that my inclination would be to, if there's any question, to require that phase 1 site investigation report. That is not a very intensive process, and through that you can determine, well, looking at his particular site, what are those issues? Is there a difference in terms of that 10 feet, whatever, as to where he would want to place the home or structure? And should there be precautions taken in constructing that given the conditions on his site for that soil? So I think that would be what I would tend to say, but I haven't had a chance to confer with your staff about it.
Thank you. I just wanted that to be clear. Go ahead, Lindsay. I'm sorry.
Years ago, I went to a training about the soil maps, and I remember them saying that it's the width of the line. So, they're drawn at such a high scale that on our really, really nice GIS programs, when we zoom down into, a little quarter-acre property, who knows how wide that actual line is supposed to be. So I think that's where the ambiguity of some of these maps fall.
So based on the discussion that you're going to have, potentially Mr. Bradshaw's issue could be resolved by simply redrawing the line. If you need to think about that, that's fine.
I don't know if we can redraw those maps. We would have to, but we will work on trying to figure out an answer to his
All right.
question.
But, something that we all, many of us watch every now and then is instant replays in football. And was the receiver's toe in bounds? To me, if you've got a line that is that wide and because of the scale, the line is actually, the single line is maybe, 200 feet wide.
Well, and these are not locally generated maps.
Yeah, I understand.
So for us to go in and, I think that's the purpose of the site investigation, is to be able to add more data because we don't have that on-the-ground knowledge by looking at those federal soil maps, so.
Okay. But I guess just my final question is that when Mr. Bradshaw leaves here this afternoon, he can rest assured that there is some process that he can follow that potentially can resolve his issue.
We will work with him to figure out what the process will be for him. And we'll have to do some more research to figure out if that means he needs to do a site investigation report or he doesn't.
Okay.
We'll work on what that answer is.
And I'll look forward to hearing what happens there. Mr. Bradshaw lives about I'll not mention Commissioner Sorensen, Commissioner. I will not mention golf shots. Let's put it that way. But he lives about a long 3-iron shot from my house, and so I see him walking all the time. So he will ask me questions, and I'd like to be able to have the answers. So thank you very much.
Other questions? Okay. So the recommendation by staff is to close the public hearing, but leave the record open for 7 days. Is that correct? To the 20th, I assume? To December 20th? And then have a third reading and potential deliberations scheduled for January 10th at 1:30 for all the items. Is that correct?
Yes, that's our recommendation.
Okay.
So we already have a public hearing for the 10th at 1:30.
But this won't be a public hearing. This will just be
Just
deliberation.
deliberation, okay.
So if that's acceptable, I can close the public hearing at this point and entertain motions. Is that correct?
Your motion is to close.
Okay. So Commissioner Bozevich.
So I'd move to close the public hearing, but holding the record open for 7 days until December 20th at 5 p.m. and approving the second reading and scheduling a third reading and deliberations for January 10th. And I don't think we need a time certain on that.
I think so. No, we don't.
Second.
And just for my clarification, is that for all four?
Yes, for
ordinance items?
all four items,
Ordinance
sorry.
1334,
Correct.
16-11, 1335, and 1336?
I assume the public hearing I was closing was for all four items, so.
Okay. We have a second. Is there further discussion? All right. Hearing none, all in favor of the motion?
Aye.
Any opposed? Pass unanimous. We get it? Okay?
Thank you.
All right, thank you. So our next item is item 12.2, or B. It's the third reading and deliberation for ordinance 1343 in the matter of amending the Lane County Rural Comprehensive Plan to add a quarry site to the inventory of significant mineral and aggregate sites, authorize mining and processing as provided by Oregon Administrative Rules, OAR 660-023-180, amending the Rural Comprehensive Plan to redesignate land from forest to natural resource, mineral, and rezoning that land from non-impacted forest land F1 zone and impacted forest land F2 zone to quarry and mine operations QM zone, requires site review of the proposed mining operation pursuant to Lane Code 16.257 subsection 4A through J, and adopting savings and severability clauses. Planning file numbers 509-PA15-05803 and 509-PA15-05804. The applicant is Old Hazel Dell Quarry. And we have with us our planning associate, Deanna Wright, our land management manager, Lydia McKinney, and our lead planner, Keir Miller.
That works.
That works? All right. So, Deanna, turn it to you.
Good afternoon, Chair and other Board of Commissioners. We last met in a public hearing in October. Staff's supplemental cover memo was posted to the board agenda page for your review on December 7th. The supplemental memo addressed some of the additional written rebuttal testimony and the applicant's final argument, as well as including a single set of the revised proposed conditions of approval. We did receive some public inquiries after the Lane County website was launched due to the updated links, and responded with redirecting people to the proper links in order for them to access the information electronically. During the open record time period, approximately 1,400 pages of public testimony was submitted and forwarded to the board since the public hearing on October 12th. Again, staff posted the testimony to the board's agenda website as each submittal deadline closed. Those deadline dates were November 1st. Anyone could submit new material. November 22nd, anybody could respond to new evidence. And November 29th was the applicant's final argument due date. Excuse me. With respect to amending the county's comprehensive plan, Lane County must use the Goal 5 administrative rules for mineral and aggregate section as the primary criteria. The criteria is complex and lengthy, so staff is prepared to assist the board in going through the approval criteria using a PowerPoint presentation, along with suggestion of using the decision matrix, which is attachment 2 in the supplemental staff report. Unless the board is ready to proceed in a different manner to make deliberations, staff is prepared to begin with the PowerPoint.
Any questions or direction from commissioners before staff moves forward?
I'm good with the PowerPoint.
Okay, proceed, please.
Again, there's an abundant amount of approval criteria for this application, so to simplify the process, it's been divided into a 6-step evaluation method. With these applications, the applicant does the research and analysis, then staff issues the staff reports and hearings are scheduled, and then the board becomes a decision maker. Step 1 through 6 are guided by the Mineral and Aggregate Oregon Administrative Rules, section 660-0180-023, which was a previous attachment, should you need to refer to it. So the way that the steps work is if the approval criteria are satisfied, then you move on to the next step. And so for step 1, determine significance. This is determined by quantity and quality. So the question at this point would be is, does the board agree that the application meets this criteria? And I'm available to answer questions should you have any.
Okay. Questions?
Well, what did you find?
Does it?
Was it?
Well, the applicant provided information from ODOT demonstrating that both of those criteria have been met. So the question is really if the board concurs with the applicant's review of the ODOT findings. That was in their original submittal.
My question is, on the first one, is what is the amount? What is the amount? Then I can determine whether it exceeds the legal standard or not.
2 million tons minimum, but the applicant's analysis showed that there's an approximate 16.9 million tons available.
Okay. And what about the second one? Is there a numeric standard that ODOT issues as to the strength of the rock, and therefore that amount can be compared to what their representation is?
Yes, I don't have that memorized, but the analysis did show that it met approval criteria.
And I would add that there was a supplemental item that was included that showed at least there was information that said that there was potentially less tons available my calculations showed that it still was around 8 million tons, which far exceeds the 2 million ton limit. Is that correct?
Yes.
So I look to the board. Does the information included in the application meet the first amount, Commissioner Sorensen?
Mr. Chair, I'm simply asking the question, is there a way for someone to give us the answer to my second question?
Digging through.
If you want, we can ask the applicant to come up and address some of those detailed questions. Again, Deanna has reviewed all of the materials, but there were several thousand pages,
Yeah.
so I don't expect that she can memorize them or have those page numbers. But
Okay.
if you want some specific answers at this point, that would be the recommendation. Either ask the geologist or the attorney to address the detailed questions.
Commissioner Sorensen, what's your preference?
Well, I think it would be helpful just to have the geologist or the applicant's attorney just give us the summary of the second one.
Commissioner Bozovich?
I'm concerned that we're taking additional testimony past the deadlines. There is a report in the documents from ODOT on the quality of the rock, asking the applicant to testify. I'm looking towards Andy here, whether we can even have them speak during our deliberations.
Well, it may be too that the answer is the staff knows the answer and staff can provide that to us. It might take us, more than today, but that's another way of doing it rather than opening up the hearing and hearing more testimony from the applicant. I just am going down the list the same way you are. I heard it on the first one that 8 is bigger than 2 and 16 is bigger than 2. I heard that, but I didn't hear the second one.
Yeah, excuse me, Chair and Commissioners, I don't disagree with what Commissioner Sorensen has just said. I think there is evidence in the record that supports the finding of all the criteria that to be talked about, including the quality of the rock. I think that information is in the record. I can't put my finger on it now because it's not a detail I've looked at in preparation for this hearing. But you're right. I think the appropriate way to deal with that is to take back the questions from the board, for staff to review the evidence that's in the record on those particular points and brief the board on that matter, rather than invite and have the applicant come up to testify at that, unless it's this board's interest to reopen the hearing, because that's essentially what we would be doing at that point in order to be fair to the opponents to this application. I think if you open and allow the applicant parties to come up and give you information, then we've got to reopen the hearing for the opponents to give their counter information.
Okay. Commissioner Sorensen?
Well, in the past, when we've had that quality issue, there are rules that ODOT establishes to make sure that the rock is of sufficient strength and quality that it can be used in state highway construction. That's the way the Oregon Department of Geology and Mineral Industries decides whether rock is good rock or bad rock, and they have a testing system for that. They have a numeric that you have to meet, and
yes, I think it's
pretty straightforward.
I think it's essentially a yes.
And I agree that having staff go down each of the steps is good, but the conclusion isn't really what we need to make the conclusion, not staff.
Correct.
They tell us it's 8 and the standard's 2. We can make the decision about whether 8's bigger than 2. Same thing on the quality.
Sure, yeah, and I'm not suggesting you wait for staff to tell you what the answer is, but analysis of a matter like, or these particular criteria has to do what are the facts and what's the legal criterion that's being evaluated, and comparing those two and deciding and making a recommendation whether it's met or not, and that's what I'm suggesting should probably happen. To the extent that it hasn't happened already, I think there is some conclusion in your reports that you have already.
And again, that's what staff has done is in the beginning of this is why we wanted to walk you through. This was the first step in terms of we don't go into the next step until we determine the significance criterion has been met. So that information has been in front of the Board of County Commissioners since October. All of that detailed information was placed before you, so you have an opportunity to review and analyze that information for yourselves if you choose to do so, rather than relying on staff's findings.
Okay. Well, I wish I could tell us what page that information is there, but as I went through the record, there is documentation that shows that it meets the ODOT's base rock testing. I just can't tell you what that number is.
And we can continue to look for that. Staff can try and pull up that documentation if the board would like to continue forward, and then we can revisit this question again. That might be a good way. Keira and I will continue to look for that so we can point that out for you before your deliberations proceed. So if the board is comfortable moving on to the next step and we let Deanna get that information, then the board can continue their discussion. It's your call.
Okay. Commissioner Farr.
Thank you. You know, we have some decisions ahead of us. Some of it's going to rely on conjecture, and some of it's going to rely on hard yes, no fact. And so wherever we can get yes, no answers, that's going to make it much easier for us to do the deep digging that we may need to have to do to make some of the other decisions. So if there's a yes, no answer that's pretty evident, I would hope that staff would be able to say yes. Does the rock meet ODOT-based tests?
Yes.
Based upon evidence, yes. Okay, that's good enough for me. Thank you. Now, we're going to ask questions. I'm sure that you can't say, well, you won't be able to say yes or no on. You know, there are some questions that are some questions that we may ask that the answer remains in question. At that point, we need to do a little bit more delving, a little bit more digging to get the answers that satisfy our needs in order to render a decision. But if it's yes or no, whenever possible, you know, make it that much easier on me if you can, please. If it's yes or no, just say yes or no, or even say based upon analysis, or based upon some places. I don't need the exact page, but I would guess that in order to go past this step right here, you've determined that yes. So, okay. Thank you.
Okay. So Commissioner Sorensen would like to have the actual testing information. I believe that it's in the record and to my recollection. So at this time, are we comfortable to move to the next step? Is it met quantity and quality?
Yeah, I would just say, you know, I've just asked the question, but I think the board has to get the answer to that question, or at least make a determination. It's not me that has to make that sole determination. Yeah.
All right. Commissioner Bozovich.
So I can't lay my fingers on it right this second, but I remember seeing the report on the quality of the rock. But I wouldn't ask the staff to answer a question yes, no. I would say yes, there's evidence in the record, or no, there is no evidence in the record. So, you know, it's not you guys answering. It's does the record support that conclusion or not? Because that's what we're basing our decision on, is a record here. Thank you.
Commissioner Sorensen.
Yeah, and Mr. Chair, I did ask that question at the hearing, and the applicant did respond to my question about that. So that is in the record.
It is absolutely, the information is in the record, both in the original written response from the applicant and, as you say, in the discussions from the public hearing.
So step 2 is defining the impact area. The Goal 5 rule requires that the applicant define the impact area. Generally, this is defined as a 1,500-foot buffer from the boundaries of the mining area. So the question would be does the board agree that the application meets the criteria of the 1,500-foot buffer area is adequate?
Commissioner Sorensen.
Well, is this where the issue of whether there are native sites near the mining area comes in, and the precision of whether or not we can identify it's within 1,500 feet of the mining area?
So again, the standard that the state law uses as a guidance is 1,500 feet, and then it's up to the applicant to demonstrate whether or not that is indeed the impact area, or the impact area needs to be beyond the 1,500-foot minimum.
Who establishes the 1,500-foot rule?
That's in state law. That's-
So we don't change that rule. That rule has been given to us by Dogami.
You don't change that rule, but an evidence could be brought forth that says that the 1,500 feet, that the impacts go beyond 1,500 feet. And again, the evidence in the record, the analysis that staff did of the information that was provided by the applicant was that 1,500-foot impact area, and again, we do analyze the impacts in there, but that is a sufficient impact area for us to analyze. There wasn't a reason to go beyond that. There might have been a, topographical reason or some kind of a natural feature that might have said, yes, there's a water feature, for instance, and so we would want to extend beyond that for some reason. There wasn't any circumstance like that again would direct us to go beyond the 1,500-foot impact area defined by the OAR.
So what about the testimony from the applicant's archaeologists and from the opponents about how this whole area, broadly defined, much broader than 1,500 feet, is affected by this mining?
The applicant concluded that the 1,500-foot buffer for impact analysis was adequate. That's what's in the record.
Wasn't there public testimony opposing that said, oh, there are impacts on the Native American heritage and various sites that are important, and they're both within the 1,500 and they're outside of the 1,500?
Actually, I don't think there was a lot of testimony. There was a lot of testimony about whether or not there were cultural resources either in the mining area or within the impact area. And I think the testimony that we've been receiving with regards to the cultural resources especially is that that there are resources within the 1,500-foot buffer. That's what the testimony has focused on, not that there needs to be an expansion to the 1,500-foot impact area. So that actually isn't something that we saw much discussion about in the testimony. Again, the question of whether to go beyond that, I think, really wasn't raised or articulated in any of the opposition. It was, again, more, are there cultural resources within either the mining area? And again, we can talk about this when we get to that criterion, but they've provided some information to address those specific concerns.
Commissioner Farr?
Just a question regarding the impact. There is a defined list of what impact is, and that's readily available either in the public record or in rule.
Well, and actually that's what Deanna will get to next, is there specific dust, noise, roads, those things that we'll go through with you. So if the board is comfortable, again, I think this is really one of those yes or no questions to some degree. If you're comfortable with this, then we'll go through and talk about those impacts, which I think is where the detailed discussion will be and where staff have crafted some conditions to discuss.
Okay. Question here is before us, is the 1,500-foot impact zone outside the mining area appropriate? Commissioner Sorensen?
Well, I guess the way I'm hearing the testimony in the totality is that there is conflict over what the impact area is. Is the impact area just 1,500 feet or is it bigger? And I'm kind of hearing from the testimony that there are people that believe that the impact area is bigger than the 1,500 feet. And I don't know if anyone specifically identified an Oregon administrative rule to say, I don't like the narrow definition of the impact area, but I did hear testimony of people who said there's going to be some significant impacts way beyond the mining area. I think that's a fair summary of the testimony. Some people felt that. presented testimony on that topic.
And in the final rebuttal, I think what the applicant did is they provided additional evidence to rebut that. So, for instance, with regards to noise impacts, do noise impacts extend beyond the impact area? No, they don't, because of the noise attenuation that they're planning to do on the site. So they looked at that question. They looked at the question that was raised about whether the, interior trucks noise was accounted for in the noise study. Again, in the response, the applicant showed, again, to their best ability, that criterion had been met. So again, our analysis of the material in the record agreed with the applicant. Again, there was no evidence that explained why the impact area would go beyond that after we reviewed the rebuttal testimony that was provided by the applicant and their consultants.
Commissioner Lycan.
Thank you, Mr. Chair. Lydia and maybe Andy as well. Isn't this quasi-judicial?
Yes, it is.
So what we have to do is we have to focus on the narrow criteria that's been presented to us. Isn't that correct?
That is correct.
I mean, welcome to Oregon land use. And if you're in Texas, there is no zoning laws. Here, we're under SB 100. This is part of the criteria, and we have no choice in this matter. So this is a narrow criteria. We have to, so when you're providing information, it's in the record, and that's what we have to focus in on. Isn't that correct?
That is correct.
Thank you.
Okay. Other questions, comments? Guess we proceed to the next question then.
Okay, let's go to step 3.
So step 3 is identifying the future conflicts of mining, and those conflicts are limited to about 7 topics, which are noise, dust, and other discharges, impacts to local roads, airports, other Goal 5 inventoried resources, and agricultural practices. Step 3 and 4 go hand in hand because a decision maker has to review the application materials in order to identify the conflicts. So under minimize conflicts under step 4, well, that's what it is. It's minimize conflicts. What does that mean? It means reducing the conflict so that it's no longer significant. And there's one of 2 ways that you can get to that. It's either apply reasonable and practical measures to reduce the conflicts through conditions of approval, or it's the applicant demonstrating that it meets established regulations like DEQ permit standards or the noise standards. Significance is a subjective term in this aspect. However, again, conditions of approval can be imposed by the local jurisdiction as long as they're reasonable and practicable. So deliberating on this step, I think it might be best using the decision matrix, but it's up to the board at this time. This is probably maybe the bulk of the deliberations, but it's, do you believe that noise and all these conflicts are minimized throughout the application materials that have been submitted?
Okay. Commissioner Sorensen, did you have your?
Yeah, I wanted to dig down into the topic of local roads, and it occurred to me that a road in England is not local when I'm in Eugene, but a road in Oak Ridge is local if I live in Oak Ridge. So is local meaning proximity to the mining site, or is it more specific like a federal highway, a federal interstate highway, a state highway, a county road, a local road not maintained by the county, or a city street? What's your view of the meaning of that?
Yeah, local road is something that our code refers to as a type of road, so it's not a proximity question. It's the, but it is sort of subjective because the question comes from, I mean, the criterion comes from state law, not so much our code. So I think when you look at this one, it's really the impacts to the roads that are impacted by whatever the use is.
And this gets to my inquiry at the public hearing about whether or not the State Highway 58 was part of the local road.
Well, it wasn't, and partly because it's outside of the 1 mile area. So again, state law has a limit to how far we can look. So we can't just go, just continually. It has that limitation. So 58 is beyond 1 mile from the site.
And the 1 mile is, what's that?
That's in the Goal 5 rule that's specific to the impacts to local roads.
Local road within 1 mile
Correct.
of the mining site.
Right. So the roads that we're looking at and have some conditions around are Dunning Road and Fish Hatchery.
Okay, thank you.
Other questions, comments?
So again, this really is, as Deanna said, the bulk of the discussion, and the board may want to, again, go through these, and we can discuss them one by one. Deanna's prepared to, I think, really help guide the discussion, because this is where there's a number of conditions of approval that either the applicant proposed or staff have proposed to address the impacts. So again, clearly there's going to be noise and dust, and there are going to be impacts to the roads from this mining site. Then what the state law requires that the applicant do is minimize those. So again, if you'd like, Deanna can talk about how the applicant has addressed noise, for instance, and then the board can determine if they want to go to the next one.
Okay. Do you want to walk through them in that fashion? Okay, please.
Okay, so for noise, you could see in the decision matrix that the applicant did find that it was going to cause a conflict. What they did was a noise prediction model, and the model predicted that it was going to exceed DEQ standards. So they initiated specific conditions of approval to minimize those impacts. Those conditions of approval are number 21 through 25 in one of the attachments that was in your staff report. I don't know if you wanted me to read through them, but did you want me to just summarize some of them?
I'm looking at them. So yeah, summarize it.
Okay, so condition number 21 is using a noise mitigation provision set forth in the written study report prepared by their technical consultants. Utilizing berms, buffers, and polyurethane screens is condition 22. Condition 23 is the use of mufflers and radiator fan controls to reduce noise level to meet the DEQ standards. 24 is a 20-foot-high natural barrier on the east side of the excavation as it moves from west to east. And 25 is complying with the noise monitoring requirements set forth in the analysis. So that was the noise conditions.
And just to note on that one, because that one was discussed again at the public hearing, the applicant provided some testimony. With regards to the noise monitoring, that is a condition, but we wanted to be clear that staff won't actually be going out there and doing the monitoring ourselves. The applicant will be required to provide us with a report, and then we will review that. And if the report is consistent with what the standards are, we can make that report available to the public as well.
Okay. Commissioner Lykin.
Thank you, Mr. Chair. So in the supplemental, though, it does state that Lane County does not have jurisdiction to respond to noise complaints generated from commercial industrial uses. That's correct?
Yes.
So on the monitoring, how are we involved in the monitoring when it isn't DEQ the responsible? Isn't the state the responsible one to monitor, or who's the actual one to who's the responsibility fall on?
Because this is a condition of approval, so you're right. Otherwise, nor does the state respond to noise complaints.
Yeah.
But the board has the authority to direct the county to do this again as a condition of approval. And so if the applicant doesn't meet that condition of approval, it's a violation of the condition, and technically we have the ability to stop the use if they're not in compliance.
This is, of course, after they go through the process with the state to get their permits to actually start mining. Isn't that correct?
Right. The applicant will have to go through an additional
Right.
permitting through Dogami and others.
And right now, even if the board decides to approve this, there is no schedule on when the applicant decides to go to. Okay. But in the meantime, so do we have a fixed time? So if the applicant does go through the process, let's say it just happens 20 years from now, they start mining, is there a fixed time on the monitoring? So do we monitor every 6 months, every year? Is there a fixed time involved in that, or is it complaint driven only?
It says at periodic time frames.
The board could specify, if you'd like us to we can specify that condition and I would recommend an annual review.
Well, and I would almost suggest that
Or it'd be by complaint.
it may be a completely different board by that time, and as well. So, I'll leave that up to my colleagues. I just want to get an idea of what your thoughts were as far as the monitoring was concerned. All right, thank you.
Okay. Other questions on the noise piece? Commissioner Bozievich?
Thank you. And I asked several questions about this at the hearing, and I did look at the applicant's final letter and all that, and they addressed some of my questions directly. But I am pleased to see condition 22 in there, because that basically puts in condition the berms that I was concerned about constructability on. So if they aren't constructible, then obviously they wouldn't be able to get their conditions met, and they wouldn't be able to proceed. The mufflers was also a concern of mine, was with the haul road from the operating face to the actual processing area. And condition 25 on the monitoring, I believe is a proper condition to make sure we're continuing that on. And if the monitoring isn't being done, or we choose, I do think we need to be a little bit more specific in that language. And I'm not quite sure, adding a time period or something where we can say, well, you haven't given us monitoring data, therefore we have the ability to say you're violating your permit conditions and we're going to terminate the use.
One thing I would like to note is that there isn't an expectation today, if the board gets through their deliberations, we would hope for a tentative decision, and then you would direct staff to go and prepare the final findings and the final conditions. So we'll make note of that, and we can work that out with the applicant and come back with a specific proposal on a specific time for that.
Yeah, I think without having specifics about that, the ambiguity will get to be an issue. One of the things, having applied for and received permits for land use in the past, in a previous lifetime here, those ambiguities cause problems on both sides, for the agency in charge of enforcement and for the applicant, whether they've actually met the conditions or not. So having a very clear and objective set of conditions, you've got very clear and objective. The mufflers on the equipment will be so many dB at so many feet. That's pretty clear and objective. A measurement can be taken, and you can verify that. There will be noise monitoring, kind of is a little bit too nebulous. It needs to say how often and what kind of monitoring in accordance with whatever the plan is. Just has to be clear and objective, and that's probably my only comment on that particular condition.
Okay. And I would add on the monitoring, I agree that it needs to be clear on a regular basis. My question to ponder would be, different conditions allow for different noise travel. So it might be more appropriate to have 2 or 3 times a year that you do the testing and be submitted, I don't know if quarterly or semi. I do know that from a past history that out at the Cottage Grove Speedway at the racetrack, if it was cloud covered and the noise didn't go very far, if it was clear and conditions are right, you can probably hear it in Cresswell. So there's different circumstances. It might be better, instead of one set time on an annual basis, that there might be several opportunities to catch different conditions.
And we'll confer with some people who have some special knowledge about that area before coming up with a recommendation.
Okay. Other comments? Commissioner Parr?
And I'll concur with that. I grew up in Tillamook County on the Trask River, and across the river from us there was a gravel mine and a rock crusher. And the rock crusher would sometimes fire up at 7 o'clock in the morning. It seemed pretty loud. Then at noon it would still be operating at the same level, and you could barely hear it. So different times of the day have different impact on whoever's listening.
Okay. Any other comments on the noise? Okay, want to move to the next item?
Sure. So the next one is dust. The applicant found that there was no conflict identified through mitigation measures because it conformed to agency regulations. The conditions of approval that covered that was 28 through 33. Under the air quality related conditions, condition 28 is maintaining vegetative ground cover on the stockpiles to reduce dust. 29 is must sprinkler interior roads with a water truck. 30 is have water sprayer bars on the crusher screens to reduce dust. Condition 31 is must use a crusher that meets LRAPA and DEQ permit standards. Number 32 is the owner must follow Dogami's best management practices to suppress dust emissions. And 33 is applicant must pave the main facility access road from Dunning Road to the scale house. And condition number 36, assure if that contracted services are present, that materials removed are stored in a covered container to reduce materials from becoming airborne. Additionally, the additional recommended conditions of approval in 43 and 44 also relate to dust. Condition of approval 43 is the quarry must provide information on blasting events to Aubrey Mountain Airstrip operator not less than 48 hours prior to such events. And finally, condition number 44, the quarry must implement and comply with the fugitive dust and daily reporting plan. So with the nearby airstrip, we did receive comments on the impacts through mainly concerns with dust and wind patterns. The applicant had rebuttal evidence submitted from their professional engineer and recommended the notification to the airstrip operator prior to blasting events. Does the board have any questions on this item?
Commissioner Bozovich?
Just one, and I just might want to work with the applicant on this. Being familiar with a couple of the gravel operations in the county and the haul, they also have to water off-site roads at times because they water the rock down before they put it in the trucks to haul it, and quite often the drainage from the trucks, once it dries on the off-site roads, can generate dust. And I just want, maybe we need to have something in there that it's not just the interior roads, but the immediate off-site roads. I know that Delta Water is part of Division Avenue. You go out to Hale Valley, they water parts of 126. You know, it's you know, I don't know exactly how, I don't want to be the one that tries to wordsmith that right now, but if you could just capture that in your final set of conditions to make sure we're also off-site roads.
Will do. Presuming, I guess, if the...
Presuming we get to that.
Okay.
So you,
comments
Commissioner Bozovich, do you mean on Dunning Road?
Yes. Well, to the point where it's necessary, that's going to be more of a judgment call. There's days at Delta they don't have to water. I guess it's River Avenue as it comes under, but there's days they're watering all the way down Division, halfway to Fred Meyer. So it depends on how many trucks are leaving that day.
Okay. Other comments on that in regarding to the dust?
And are the commissioners in agreement with adding condition 43 and 44, which is related to providing information to Aubrey Mountain Airstrip, and condition 44 is implementing the fugitive dust report plan.
Those are two new conditions that staff is recommending and the applicant has agreed to, that we're recommending that the board include if they choose to approve this.
I'm in agreement, and I believe that 43 is important because, in my experience, the blast sometimes can create a plume of dust that, with the right conditions, could blow and impact the neighboring airstrip. So I think that that's a good requirement to give notification.
I think that was the largest concern with that quarry up off of Territorial and High Pass during blasting.
Okay. It looks like seeing an agreement on the inclusion of 43 and 44.
So we're on other discharges right now, which is diesel engine emissions. The applicant found that there was no conflict identified through mitigation measures and conforming with agency regulations. And the conditions of approval related to that are 34 and 35. Condition 34 is using off-road equipment that meets Tier 2 off-road engine standards. And 35 is limiting on-site idle times for heavy-duty diesel truck engines to no more than 3 minutes per truck trip.
I guess that 35 is a good one to put out there. 3 minutes of idling per trip, but my experience is most people don't. That means most likely if it's taking longer to load your truck or you're waiting in line, that means you shut it off, and most people don't like to shut their vehicles off. So that one might have an enforcement concern.
Well, it was one that the applicant proposed, so presumably they're willing to comply with that.
Okay. Other comments on those items of other discharges? Does that include runoff too?
Say again?
Will that also include runoff too, or are you going to?
Yeah, this is the next one is other discharge stormwater. The mitigation measures and conforms to agency regulations was what the applicant is claiming that they comply with the standard with, and that's condition of approval number 2, which is obtain and comply with DEQ approval for a spill prevention control and countermeasures plan for the quarry. Condition of approval number 8 is applicant owner must comply with stormwater erosion control plan prepared by their consultant and or as modified by DOGAMI, because DOGAMI is also a regulatory agency that's going to look after or look over their stormwater management control plan. And additionally, condition of approval number 46, which is prior to mining activity in phase 2 of the mine plan, the applicant must establish a baseline for water quality in the intermittent springs located on the western slope of TV Butte and must conduct water quality at the springs at 6 months intervals during the life of the mining activity in phase 2. And what they would do is provide that summary to the City of Oak Ridge and to Lane County within 30 days of sampling.
And we should note, this was, the City of Oak Ridge provided some testimony that they were interested in having some water, some monitoring of the wells done. For quality only. Water quality. And so the applicant provided some rebuttal testimony regarding the fact that the wells also serve the industrial park. So it's not just water that serves the quarry site. So they made an alternate proposal with that condition.
So moving on to local roads within 1 mile of the quarry site, the applicant did find that there was a conflict with this, and the reasoning behind it was the site distance and vehicle off-tracking on Dunning Road. So they implemented about 10 conditions of approval and 2 additional conditions of approval. So the transportation-related conditions begin on proposed condition number 10 is access to the site is on Dunning Road. A new driveway must be constructed 30 feet wide, consistent with the lane code and the TIA, the traffic impact analysis. Condition of approval 11 is the applicant owner must remove the vegetation and earth embankment at the site driveway intersection with Dunning Road. 12, 13, 14 are advanced intersection warning signage conditions for eastbound and westbound directional on Dunning Road. Condition of approval 15 is dealing with the pavement analysis for 20-year design life based upon the existing traffic volumes on Dunning Road and Fish Hatchery Road. The trigger for this, what did you want? Transportation planning to talk about this? I don't have it memorized. So any pavement structure determined necessary to meet the 20-year design life must be constructed by the applicant. It's either prior to the addition of 20 or more daily truck trips, within 5 years of commencing operations, or within 10 years of commencing operations, provided that pavement condition index, or PCI, has not fallen below 70, whichever is less. Should the PCI fall below 70 after commencement of operation, the applicant owner must complete the necessary pavement mitigation within 1 construction season.
And again, this was a condition that, we revised, the applicant chose to revise during the open record period to put that timing element in it so that the repairs would be, the analysis would be done after there were some impacts on the road rather than doing the analysis before there were impacts.
This was one of the areas that I had a little discomfort to say, 20 or less a day, we're not going to do anything with the road. And so if I understand what you just read me back is that it's really about the pavement condition index 70. If it goes below 70, it triggers that the upgrades and the necessary improvements need to take place. It's been my experience that dump trucks and loaded dump trucks are probably one of the most hardest vehicles on the road because of their short wheelbase and the payload that it can cause the road to deteriorate quicker. And it doesn't matter if it's 10 loads or, the more loads it's worse, but it does happen. So I think that that's a more accurate way to determine whether or not the road is holding up to the appropriate amount of use and triggers the improvements that are necessary. So I appreciate that addition in that criteria. Is there other comments? I noticed too that, if I understand it rightly, the improvements from Fish Hatchery Road up to the, it appears the railroad right-of-way is going to have to take place sooner. The right-of-way, is that right? To achieve the 24-foot width?
That's condition of approval 17.
17, yeah.
Yeah, that's a separate, so that doesn't have the timing.
Pardon?
That is a different condition, so it doesn't have that same timing. They would have to do that.
Okay, but that's something that has to be, it looks like needs to be done right away.
So
And then there was a question about the railroad crossing itself. Has there been any additional information that was received since we had the hearing about if there's going to need to be widened or some sort of upgrade?
It will need to be widened. That has been determined. How it's widened, and again, that's where it gets into that tricky, it's an ODOT rail order, so through that rail order, when the applicant, if they get approval for this, they'll actually ask Lane County, because we apply for the rail orders, and so we'll work with county transportation and engineering staff, will work with ODOT to determine what the improvements are, if there's warning, et cetera. And then the way the condition just reads is that the applicant will comply with the ODOT rail order, because until they have more information, they don't have the design. They don't do that until actual development is occurring.
Okay. Other questions then? There's the roadway.
additionally, condition of approval 45 and 47. Would the board agree that those should be added? 45 is the eastern access point on Dunning Road, which is also known as the Red Gate, must not be utilized by commercial truck or other vehicles for commercial aggregate hauling processes. So during rebuttal, the applicant was just wanting to clarify here that the Red Gate was not going to be used for commercial purposes. They have reflected that in a revised set of site plans to show that that's not on there any longer, and they just wanted to codify it here more, that's stating it's not going to be utilized for commercial truck as a condition of approval. So,
I mean, I agree with that component because there's no road enhancements tied to further up the Dunning Road to that location, and it's not needed. I think it should be clarified that that criteria be added. Others? Okay.
and then on condition of approval, proposed 47 is easement provided to the goats, and forgive me, I don't know the acronym for that. I think it's the local bike.
It's a mountain biking.
Mountain biking club that's up in Oak Ridge. That the applicant was gonna transfer an easement to a public body so that they can use a portion of the property that's on the eastern access of Tax Lot 1900, where the Red Gate is, and to transfer that easement so that they don't have to go down Dunning Road, and they can use this as an alternative route if they wish. So is that a condition of approval that you guys would be wanting to entertain? Okay, so we're going to move on to the airport conflict. In the matrix, the applicant had said that the airport is not applicable. And one of the reasons for it is because the OAR is trying to ensure that the mining operation doesn't maintain a water impoundment that attracts birds, which can cause safety conflicts to nearby airports. So the airport is not, the Aubrey Mountain Airport is not a public airstrip, nor is it contained within the adopted regulatory zone in Lane County. So that's why the applicant is getting to the conclusion that the airport in the OAR is not applicable. Its staff agrees with that. You guys?
Not seeing any questions or comments regarding that.
So moving on to the Goal 5 significant resources, only the resources on an acknowledged Goal 5 inventory can be reviewed on this level. In the application, what they found was that Class 1 streams are within the impact area, wetlands are within the impact area, and fish species within the impact area. And they found that no actual Goal 5 inventory sites were on the subject property. So they concluded that the mitigation measures and conforming to agency regulations and their condition of approval met the approval criteria. The condition of approval number 2 for spill prevention. Condition of approval number 8 for stormwater erosion control plan. And a condition of approval number 26, which is mining and processing must not occur within 50 feet of the unnamed creek on the east side of the property. And finally, additional condition number 46, which is the establishing the baseline for water quality in the intermittent springs located on the western slope of TV Butte, must conduct water quality at the springs at every 6 months intervals.
And that water quality, once again, is the applicant's burden to provide that information, correct?
Correct, to the City of Oak Ridge and Lane County Department within 30 days of sampling.
And OGAMI, yeah.
Okay, so moving on to agricultural practices, a conflict was not identified because the applicant stated that due to the limited and small non-commercial agricultural practices taking place, they found that conformity with ORS 215.296 is found. So that would conclude the step 4, minimize conflicts step. Is there any more questions on this?
And if the, Commissioner Sorensen, if you'd like, I did find the place where the applicant addressed the quality issue. I can either direct that to you after this meeting. I can send you a link directly to that, Commissioner. It goes into quite a bit of detail here. So if the board wants me to read that, I can, but I just wanted to let the board know we did locate that.
Mr. Sorensen, do you have a preference? Is it?
If it's in the record, then that's sufficient.
Okay, thank you.
Commissioner Bozovich.
Thank you. So while we're still on the minimize conflicts, I wanted to go back and revisit the Tier 2 standard for off-road diesels and ask that you, I'd like to see that be Tier 3, which is 2008, or basically Tier 2 is only 2005 standards, and Tier 3 gets us up to 2008 for emission control. I don't think that's a big question to ask the applicant to take care of.
The board like to see us change that if the
applicant's agreeable. I mean, it seems not a terribly onerous request, in particular with that being a airtainment, and it may be required by LRAP anyway in their permitting, but
we'll look into that and get more information for you next time.
And then secondly, while we're still on that subject, just so we can talk about this publicly, I'm pretty satisfied with what you've provided me in the report, but can we review the big game and why that is not being reviewed as a Goal 5 resource that has to be addressed under this application?
Well, the applicant has stated that the Goal 5 big game doesn't need to be completed because the Rural Comprehensive Plan was adopted in 1984. I mean, I don't.
I think
The EC analysis only triggered if they couldn't minimize conflict. I think it's only triggered if. Right, it hasn't been identified in the inventory, and it, isn't there something also that if it's not identified as a conflict? Right, it's the same as the cultural resources. It's another one of those resources that is not being inventoried and therefore is not allowed through the Goal 5 rule for us to make requirements around.
I think to follow up on that, in the little bit of work I've done on this, I think the rule is here that you're looking for, or the rule, the Goal 5 rule on mineral and aggregate requires a finding of conflicts with respect to identified and inventoried Goal 5 resources. And my understanding on this site, that big game is not one of the identified inventoried Goal 5 resources that you need to compare to see if there are conflicts one way or another. And as you recall, we could be talking about conflicts to mineral aggregate sites from big game, vice versa. But here, the big game is not identified, so there's no analysis that needs to be done to see if there's a conflict there.
I just wanted, there were lots of testimony relative to that particular issue, and I just want to make it clear that, one of the things we're constrained by, and Commissioner Lycan mentioned this earlier, we're under a quasi-judicial process. We have to go by the criteria that the state law sets us, to review by. We can't go outside that criteria in reviewing the application. And then, of course, we can't go outside the record either. So there's a couple constraints on how we make our decision. It has to be against the criteria as outlined in state law and our code, and it has to be from the record we make our decision. I just want to be clear that big game, unfortunately, is something that is outside of our ability to look at because it's not an identified Goal 5 resource on this particular property or within the 1,500 feet.
Right.
There's, to open up, I don't think a Pandora's box, but to further enunciate that, there could be conceivably things that would transcend, if you will, the Goal 5 rule here. For example, if we had an overlay of federal law that prohibited any sort of disturbance of an endangered species, that might be an overarching rule that we'd have to comply with, notwithstanding the Goal 5 rule. But there's nothing I'm aware of that, or no laws I'm aware of that supersede the state law and the Goal 5 rule that would indicate that that's necessary here with respect to big game or the other issues out there.
Thank you.
Commissioner Sorensen?
Andy, I forgot your last name, Mr. Clark. I was interested in knowing a little bit more about the issue of the burial grounds and whether or not that may not have been inventoried as a Goal 5 resource, but due to treaty and federal laws protecting those kinds of resources, are those something that the board considers, even though it's not within the Goal 5 inventoried resources, that the way the state legislature is written is to narrow it down to Goal 5 inventoried resources? So there could be elk wandering around all over the place, but if it's not identified in a plan, then the applicant isn't held to standards about whether there are elk or not unless the county's plan has included it. And as we heard in the testimony, county's plan hasn't been updated for 20 years. So separate from this business of elk or big game, you kind of open the door to these federal issues or tribal issues where there's the letter in the file from the Warm Springs tribe, and they're raising these cultural issues. Is that something the board can't consider because it's not inventory Goal 5 resource? And 20 years ago when Lane County last adopted its land use plan, nobody thought to include that? Or is it something we have to address because it's part of the, I would say, complicated relationship between tribal rights and sovereign rights of the state and of the tribe? And what's your view? Do we take that letter and you say, well, that letter is, we got to go by that letter because that's on the basis of a federally recognized tribe with tribal interests?
Let me jump in and try to answer. 2 points I'd make. One is that there is a state law that governs cultural artifacts that may be uncovered in the midst of work on the site. I don't know that we have a condition about it, but we do have a condition. There's a condition also, it's kind of overarching state law, that if during the work on the site cultural artifacts are discovered, under law, work needs to stop and that needs to be further evaluated. So that's one additional element beyond the Goal 5 rule that would come into play. The bigger issue, though, I think that you're asking about is whether there are any other laws or treaty rights that would apply with respect to these cultural historic artifacts. And the answer is, yes, there may be, and that is if there are federal law on point, it would apply and potentially could control. The issue of the 1855 treaty has been raised. I've looked at that a little bit on the question of whether there are reserved rights with the natives that might control here. I haven't seen an argument beyond that, that is to say it applies. I guess the question I have is how, because when I look at it, I don't see any rights flowing from the treaty that impact this particular development. Where I've seen issues relating to that treaty come into play is when we're talking about common rights such as fishing rights along the Columbia, which I think is where that Supreme Court case, I think that's what it was dealing with, where you have the state of Washington attempting to cut off access rights to Native Americans to do fishing where they've historically done fishing and do it in a manner they've historically done it. Supreme Court eventually said, no, you can't do that because those were rights that were not ceded away in those treaties that were historically practiced by the natives and continue to have a right to do that. I don't see that as relevant here. Perhaps the analogy works where if you look at privately owned timberland in the area, in the state, there's, I don't know how many commissioners do it, would know better than I, how many millions of privately owned timberland we have in the state. Much of it, I'm sure, historically used as hunting grounds, fishing grounds for native tribes. I've never seen anything indicating that treaty, for example, would give Native American rights to go on to private land if it was otherwise closed to engage in historical fishing rights. And that's similar to what we have here. We're talking about private land and whether the possibility that there are artifacts there and the use of it as historical burial ground, for example, would mean that no activity could go on the site. If there's an argument along those lines to be made, I don't know it and I haven't heard it, and it hasn't been made that I've seen as part of this this application. I can't recommend to you that argument that it may apply somehow defeats the rights as I understand them that the applicant has under the existing rights of Oregon law or the Goal 5 rule. I'm a convoluted answer, I'm afraid, but it's a nebulous area of law.
I was hoping that we could narrow down not what the private property rights are of the applicant or the tribe, but what the government activity is. The state of Oregon tells local governments they have to rule on these applications. So it's not the private land or the tribal rights. It's more like, well, what are we supposed to do? Are we supposed to allow for and take in to our record letters like the letter from the tribe, and they say there are resources there, and I get it that your view on the big game is, well, that's not part of the county's inventory, so therefore we can't consider it. I get that. I don't quite understand whether we are or are not considering, and it's your recommendation that we not consider the cultural resources because they weren't inventoried either.
Well, yes, essentially, if you're looking at that context, that there weren't any inventory cultural resources there, so those conflicts don't need to be analyzed. But beyond that, there is evidence that evidence has been admitted into the record that's in front of you that there may be artifacts there. There's also evidence in the record before you that folks, Heritage Associates, I guess, have done studies and evaluation analyzation on the area and have not found the presence or a good reason to think there are artifacts there. And so in that extent, you're able to weigh the evidence and make your conclusion.
Well, it's just a factual issue of whether we think the archaeologist for the applicant is correct or we think the tribal, the letter from the tribe is correct. And it's something the board has to weigh as part of the fact finding of this whole thing.
Correct. Although I'll remind you that on a strict application of the rule, the secondary question is, okay, if you think there are artifacts there, are they actually inventoried ones? Now, that's relevant to the Goal 5 application analysis. Conceivably, if this board were convinced that the weight of evidence was that there were cultural or historical artifacts on site, that would be disturbed by this mining operation, you can impose additional conditions based on the state law that protects those things. But as that's analysis outside the Goal 5 rule, really.
Okay. Commissioner Bozovich.
Thank you. I think somebody just approached the dais and handed paper to us. The record's closed on this application. So hopefully that wasn't new. Hopefully it wasn't new information. And also, I'm sure that, you know, if we're going to start allowing folks to hand commissioners information, we have to allow the applicant to do the same thing. So please, it's hard enough to concentrate on the thousands of pages of documentation we've had to read and the laws that we're trying to make a decision on. I'd appreciate it if we don't get handed new information right now that's outside the record.
Thank you. Commissioner Lycan.
Thank you, Mr. Chair. And just want to remind us that the Whole Foods project was actually stopped for a period of time because of issues with artifacts that were found. Cultural artifacts were found. So that project was stopped until the authorities could actually go in and take care of that. So before it could be resumed. The other issue is that when you were bringing up about this, doesn't a lot of this occur though? We're doing one thing, but when you actually get into the process of mining, isn't this where the Dogami, the tribes would get together and talk about and actually maybe come to some sort of an agreement on moving forward? I'm not sure. Is it applicable here? That's the question I have. Is it applicable here, or is that more of the process where the state then is through their negotiations to actually grant the mining permit itself, then works with the tribes? Is that, am I incorrect?
Well, as it plays out, probably that's where it would be relevant. It potentially could be relevant at this stage as well. As I say, if there had been some items identified in the inventory or other reasons, or if there were a federal or treaty law that applied, for example, that would seem to prohibit this, that would be relevant here and at Dogami in both places. But at this stage, yeah, I think to the extent the activity on the ground, if there is going to be some, it would be at the Dogami level where they would entertain those issues now.
Well, and I just again want to point out that the Whole Foods project was stopped until they addressed the issue of the artifacts that were found. So that is in play, and that's something I would strongly support.
And again, there is, as Andy noted, a condition of approvals, obviously, that be the same thing that was triggered in the Whole Foods incident. And I think, Commissioner Lycan, you do raise a good point, which is that there are additional opportunities for the tribes to work with the applicant through the Dogami permitting process.
Not in this process. That's later.
Okay. Any other questions for staff? Excuse me. We have a record and we have process that we have to follow. We can't take any additional information or suggestions. I'm sorry, that's not the process.
We are.
We are. It's in the record.
It's in the record.
Yeah. Okay.
We do not need to answer that. The record claims.
553-3555.
I appreciate the information. It's all submitted in the record, and we're working through our process at this point. Thank you.
So the next slide Deanna has is actually in regard to the ESEE analysis. So I know you talked about that already, but I'll just give her a chance to walk through that quickly with you here as well.
So step 5 would only come into play if conflicts cannot be minimized, and ESEE stands for economic, social, environmental, and energy impacts. And again, this is only formalized if conflicts can't be minimized. Step 6 would just be the decision-making time. the board finds that the application meets approval criteria, then we're compelled to approve the application.
And again, what staff is recommending that the board do today is have the deliberations and then give staff a tentative recommendation so you tell us where your decision is going, and we will provide revised findings. And if it's a decision for approval, we'll provide those revised conditions as we discussed. And we'd come back, I think it probably would be in February before we'd come back for that final decision. But
Okay. Commissioner
So
Sorensen.
what's the bottom line then on the letter from the tribe, from your perspective?
well, again, they have the starting point is like with the big game is that it's not a cultural. It hasn't been inventoried. So the letter is saying that there may be resources within the impact area, not necessarily within the mining area. They haven't provided any additional information with regards to that. So again, the information was submitted to us identifying that as a possibility, but with no further evidence. And again, without this being an inventoried resource, there isn't really any additional information we can request from the applicant.
Yeah, just add on that the Oregon revised statutes around the mineral and aggregate rule are very clear in what the county may evaluate in their approval criteria, and it uses the term significant inventory. And even though there may be cultural resources near the site, whether or not the county has adopted it on its significant inventory of resources, that's the key determinant at what the county can look at it. Similar to the big game question that was raised, we do know that there's elk present in the area, but they haven't been inventoried on our significant list of Goal 5 resources. So that's from the board's perspective, evaluating this under the rules that are in place. Those are sort of the guidelines and the framework that you look at what's allowable under this process, understanding that there are, as Mr. Clark mentioned, a whole net of other federal rules around cultural resources. But in this evaluation process, the significance is the key determinant, and that's what these resources aren't on the county's adopted inventory of significant.
And I'll just make one final comment, and that is that the work that was done by the applicant's archaeology firm did actually do an inventory of the entire mining site and didn't find any resources, and then also did look in the impact area, and they did find some artifacts that they've inventoried, but again, they didn't find any evidence of the burial grounds, for instance. So while one could argue that the applicant didn't have to provide that analysis, the applicant does have quite a bit of information in the record that was conducted by their consultant about exactly what was found on site, because they did do some site reconnaissance.
Okay. Anything else, Commissioner? All right. So step 6, decision
Step
making
6
process.
is the last analysis in the OAR. This is where the decision would be made, whether or not the application meets approval criteria by the board.
So essentially, this is the deliberations time for you to have any additional questions for us. And again, if you can provide us with some direction, how you'd like us to return with a final decision for the board.
Okay. So staff's recommending additional 43 through 47, is that correct?
Yes, Commissioner.
And then I heard in our conversations, I got 3 items here at least that I jotted down. Hopefully you were paying a better attention than me, but the first one was some concrete reporting on the noise readings. It was mentioned annually, semi, or potentially quarterly on those. Then Commissioner Bozovich brought up concerns about, I guess it would be dust concerns in regards to not only the site, but further down hypothetically, if there was any type of tracking or something that went down Dunning Road further, that would be language included. Is that correct, Commissioner?
That was watering for dust control.
For off-site roads.
Okay. He also added, I believe it's for 34, upping the Tier 2 criteria to Tier 3, and I think that's in regards to the 2008 emission controls. Is that correct? Standards?
Those are the three that staff got as well, so.
So there's only 3? Okay. Any
And of course, that's provided the rest of the board agrees with those. Those were my suggestions, but.
One thing that we didn't touch on, and I know that it's documented well in here, but, and it's, I think these things sometimes come up as just, I guess, things that you think about. So in regards to the old landfill site, it's clear that the old landfill site's not going to be disturbed, and it's essentially blocked off. One of the things that happened in the county was in Cresswell, there was a land development, and we used historic maps for the landfill site, and the property owner came in when he was working and uncovered a bunch of tires that weren't actually documented on the site. So in that case, if we're pretty clear that we've documented the old landfill site and its parameters, are there provisions in here that would cease and desist if there was something uncovered that was not documented?
I actually thought we added a condition because the Planning Commission had that same, concern. So I think we did put some language in there around if there was any. Well, how about, what I think we can do is Commissioner Stewart, again, if the board agrees, we will either identify it for you when we come back next time, or we can craft a condition that for the board's review next time to address that. So you're suggesting that if there is any disturbance, if there's any evidence of.
Similar to the archaeological site, if you found that you ran into a grave site or something, you cease and desist and go through the process to take care of that. And I would assume the same thing would apply, or I believe it needs to apply to the landfill too.
Okay, we can craft one like that.
Okay. Other comments? Commissioner Lycan.
Thank you, Mr. Chair. And I also think that we were going to try to make sure there's clarity involved in the monitoring process.
Right.
Is that mentioned?
Yeah.
Okay, all right, thank you.
Commissioner Sorensen.
It seems like the board's moving towards approval, and I just want to register my view that I do think that those cultural issues that are similar, in my view, more like federal issues that are beyond the scope of a Goal 5 inventory for Lane County that have to be addressed by the county, and it doesn't seem like that's really the will of the board to do that, but I just want to register my view. I think it should be done. I think it's an important part of the process, and the failure to do it means that the decision by the county can be looked at and evaluated further up the appeals channel because the county didn't address it.
Well, and staff are coming before you in January to have a strategic planning discussion, and we certainly can include that in our discussion then. I would note if there was any, if the board directed staff to do an analysis at this point, it wouldn't apply to the current application because, of course, it's vested on the date that the application was submitted to the county. So only those standards would be applicable.
Commissioner Farr.
Thank you, Mr. Chair. Actually, my question is for clarity regarding Commissioner Sorensen's comments. Correct me if I'm wrong on this. Commissioner Sorensen was suggesting, as Mr. Clark said, that if higher laws, federal laws, superseded any of the decisions made here, federal laws could come into play and affect the decisions that are being made locally. Is that correct?
I would probably not use the word federal law. I would probably just say federal rights, because he gave the example of the elk as being a non-inventoried Goal 5, and then said, well, that wouldn't apply when you're talking about a federal right such as the Endangered Species Act. So if the animals were endangered, it would apply. If the animals weren't, it wouldn't apply. So I think the same thing's true in the cultural arena, whether it's the National Trust or Historic Preservation Act that protects, federally protects cultural resources, or whether it's a tribal right and created federal right. I would just use a broader term, federal rights.
And I just want to remind the board that the discussion and the decision has to be made on evidence in the record, so there hasn't been any evidence that was submitted into the record that makes staff or our county council aware of any other federal standards that would apply. The same is true with regards to the treaty it wasn't submitted into the record, but our county council did do some research, and again, there wasn't any evidence. The opponents didn't explain why that treaty was applicable and how that applied. So I'm not sure if Commissioner Sorensen, if you were asking for us to do an analysis if there were any other federal laws, but again, we cannot bring any more information into the record at this point.
And back to my clarity question. Isn't there a provision? I mean, we don't know necessarily the federal law that may apply, but if a federal law does apply, does it, I mean, it rains down upon us. We don't have any question. We don't have to ask for it. If it comes, it comes.
That's correct.
So if there's a federal law surrounding a treaty or a federal law surrounding an endangered species or whatever the federal law may be, if it is discovered subsequent to our passage of this, then it becomes applicable whether or not it was in the record to begin with?
Well, yes. I mean, federal law, the question is whether it's been triggered and does it control. I mean, there may be some other, so if there are federally protected rights that are somehow involved in this application, making the federal law applicable, that may control the board's decision here in some respects, completely or partially or whatever. So in other words, federal law may apply. It's a little bit more difficult question to argue after the fact, that is after a decision's been made, oh, by the way, federal law applied and it compelled you to do X rather than the Y that you did. That could be the case, but not necessarily, because there's a bit of an obligation to litigate all the relevant issues at the same time. And if there are federally impacted rights at stake, the decision makers need to be made aware of those by parties who later may claim federal law control. Now, there's been some comment about treaty rights, for example, but nothing that I understand as thoroughly enunciating how that affects the decision here. So I just say there's a little bit of gray involved there, that federal law, I think, if it applies, yeah, it controls to the extent it applies now. Later on, if the argument's not made and somebody makes it in a different context, it may or may not control at that point.
Okay, so specifically then regarding a treaty, no indication has been made as to whether or not the treaty is applicable. But if the treaty is applicable and it is a federally signed treaty, then it seems to me that that it would be made retroactive. I mean, if it's federal law, we don't supersede federal law.
No, and that's, I think, the point I'm trying to make is, yeah, if it applies here and there's some rights that are protected by the treaty, then yes.
And whether or not it's been argued at this point, or whether or not it's been introduced at this point, rights that come up later that are applicable, whether or not they are part of the record. If it's federal law, then it is applicable.
I'm not sure I followed. I guess the point I'm trying to make is if after the decision is made here, if someone later on says, hey, here are some rights you failed to account for, here's some federal law that you didn't apply, you need to reverse the decision, that may or may not have any weight, because there's always a difficulty in making claims after a decision that could have been made prior to the decision. That's the point I'm trying to make. It's a matter of I think we call issue estoppel. Now, how issue estoppel might apply in a federal lawsuit, for example, compared to a county commissioner decision, I can't tell you right now. But that's the issue at stake is if you got a claim, make it now. And that's, I guess my point here is if there's a claim federal treaty rights or other federal law apply and control this board's action, I'm not aware of it. And what I've seen in the record so far with respect to this treaty is essentially the treaty applies, therefore you can't do anything. And that's the gist of the argument I get, and that ain't enough.
I understand that, Mr. Clark. Thank you. And what is probably not as simple as endangered species. I'm thinking about, for instance, the snowy plover. In recent years, land use decisions have been made that have been superseded by the fact that the snowy plover nesting grounds have been located in areas where other land use laws have applied, and thereby those land use laws no longer apply.
Yeah, and I think to clarify a little bit, I think when you get around to, there's an implementation stage of whatever use is allowed, and if a federal law comes in later and says, notwithstanding the decision you made earlier, which is legally okay, but there's some federal law to prevent you from implementing it, that's a little bit different decision-making realm, but I agree. In that case, federal law would say, no, you can't implement that decision that was made prior. Okay. And that's possible here, sure.
Okay, thank you.
Mr. Sorensen?
I seem to recall part of the burden of the applicant is plan must comply with all laws. Is that still part of the applicant's burden? There's kind of catch-all. It says you will comply with all laws.
I don't know if we have that catch-all in place. I think it's a true statement, but I don't read that as being that the applicant needs to go prove that every legal criteria that may or may not apply has been satisfied, because where would it end?
Yeah, it might be, you would never be able to say for sure that you had, but I believe it's fair to say that we can't approve something that does violate another law if we're able to identify what that is. And I guess what I'm focused on here isn't a treaty right between the Confederated Tribes and the U.S. government. I'm really focused on the archaeological, historical, cultural resources that are being affected by this, and whether specifically, to get down to the specifics, because Commissioner Farr mentioned the endangered bird and the Federal Endangered Species Act. I want to talk about the National Historic Preservation Act and whether or not we have done what we are supposed to do to make sure we preserve and protect historical, cultural, and archaeological resources. And I get it that that's not part of the Goal 5 inventory. I get it that the county in 20 years hasn't inventoried these resources. Maybe it will, maybe it won't. That's not something we get to decide today. But what about these laws that do exist that we're supposed to uphold that say we will protect cultural and historic resources?
Yeah, I mean, to answer the general question, I think that kind of law would apply. Whether it controls here is the issue. And in theory, one could make the argument that the board has that requirement under federal law to ensure that cultural resources are protected. And the argument then about whether or not the board's failed to do that here would depend on whether or not there are any cultural artifacts to be protected. And then you're back to that balancing or weighing of the evidence that's in the record. Are there any there or not?
And I guess I would respond at that there's a report right in our record here that showed that there was 31 archaeological surveys that were discovered within a mile radius of the site. 12 of them were within the 1,500-foot buffer, and there was no cultural artifacts found within the site. But there was within the 12, within the 1,500, there was 7 of them that did have come back with some sort of an items. One of the items I recall was a wooden pipe that carried water, I believe, down to the fish hatchery. So once again, in the record, there's nothing in the record that shows that there's reason to believe that there's items on the site in the surveys. There was additional testimony added after a public hearing. There was, a record of comments by my great uncle Lawrence Hills that talked about different aspects of it, but nothing that was concrete or showed that it was specific to that site. So I do believe that the record does include a great deal of this information, and it doesn't show that it reveals that this specific site had anything of significance on it. Mr. Miller?
Chair Stewart.
Go ahead.
Sorry.
Thank you.
Go ahead. Go ahead.
So if I could just clarify a little bit on Commissioner Sorensen's question. I think it's already been stated, but if it hasn't, I just wanted to reiterate that getting to the point that there is this understanding there's the Goal 5 significant cultural resources, but then there may be these other cultural resources which the applicant has provided information about in the record that we just went over. But I just want to point out and reiterate again that staff has included a general blanket condition of approval that speaks to the fact that in the event buried cultural deposits are encountered during the project activities, the applicant owner must comply with ORS 97, 7.40. This is the archaeological objects and sites requirements that are under the state rules, which basically requires a stop work at the site, and then they have to contact the state SHPO board to evaluate that. So there are some protections built in under state law, and then I assume there are similar provisions that may not be enunciated in the conditions of approval that have to do with the Antiquities Act and the Archaeological and Historical Preservation Act, et cetera. There's a lot of other federal rules that could govern and work the same way, but there is a condition of approval that basically requires stop work if resources are encountered on site.
Okay.
And certainly those federal laws don't require that there be a condition. They apply whether or not we make them a condition of our approval or not. Same as the state law.
Okay. Commissioner Bozovich.
So I just want to make clear that when we talk about Goal 5 resources within the impact area, the question is have they mitigated? And it's not whether they're present or not, or and all that. There's some of that. But the question is there mitigation in either the plan or the conditions that get us past that? And I think condition 9 clearly, it mitigates if they do encounter those, because we do not, as we say, it has to be an inventoried resource. And even when you get to the National Historic Preservation, they actually talk about items that are in the National Registry or eligible for the National Registry, and I haven't seen evidence that we've been provided that there are items in either of those within the mitigation, within the impact area. I would also, remind us a little bit that Lane County is a subdivision of the state of Oregon, and we are a home rule county, which gives us a fair amount of power, except for where the state has generally taken that power from us. And under Senate Bill 100, they removed a lot of our jurisdiction on land use and centralized it within the state. And we operate under the state's rules for land use. So we're given a set of rules to do approvals by, and to make plans by, and to do process by. And those rules are pretty clear that these are criteria we have to make our decision under a quasi-judicial process. And, there is opportunity beyond our process for folks, who have entered stuff into the record and are parties of record to appeal that decision with the state. But, what we have here in front of us is a decision we have to make based on the record under the criteria that the state has given us. And unfortunately, we don't get to make decisions about federal treaties in that process, or things that aren't inside the criteria that are identified Goal 5 resources and significant Goal 5 resources under our Rural Comprehensive Plan. So, I appreciate the concern about cultural resources, and we have added a condition here, hopefully that will prevent any damaging of cultural resources. But in our decision process by the state, I don't see where we have the ability to deny this application based on that particular issue under the rules that we're given. So I would hope that if there are concerns about that the tribes talk with the state legislature and maybe change the land use rules that direct counties and municipalities how to execute the rules that they've centralized under Senate Bill 100. The place to argue that probably is in Salem or Washington, D.C., not necessarily in this process, but it may be something that is applicable upon appeal either at LUBA or even the Court of Appeals if LUBA doesn't rule in the appellant's favor. At this time, though, I have to look at what are the criteria the state's given me and what is the record. And I think on this particular case, we've provided a condition that mitigates any potential impacts to a resource that has not been inventoried. So I think we've gone beyond even in that.
Other comments? Commissioner Farr.
Thanks. And I'm just following up a little bit more on artifacts. And I'm looking at 97.750 here. Is that the one that you were citing earlier? It says, except as provided, no person shall willfully remove, mutilate, deface, injure, or destroy any cairn, burial, human remains, et cetera, et cetera. That's what you're referring to. And that supersedes everything. I mean, if that happens, then work stops. Okay.
How does that actually happen? They're uncovered by heavy equipment and they're destroyed in the process of being discovered.
It's
Not our criteria.
Yep. Other questions for staff or comments? Okay. So I guess staff is looking for direction to either proceed with a tentative approval with some adjustments, bringing back further adjustments to the criteria or conditions, 1 through 47 with the items that we've talked about, or not approval and state the reasons why. Commissioner Blazevich.
I'd like to move that we tentatively approve ordinance number PA 1343 and directing staff to provide a revised ordinance and findings and the final conditions and set a fourth reading and final review and approval. I mean, is there a date you guys want that fourth reading?
February 14th.
February 14th? Okay. Fourth reading on February 14th for review and approval. And those revised final conditions will include those 3 conditions we discussed earlier about Tier 3 engines, off-site dust control, and
reporting.
Objective standards for the monitoring.
Second?
Second.
Further discussion or comments? So this is just this isn't the final vote on the ordinance, so it can just be called by the chair or roll call.
Yes, it's not an ordinance.
No.
Just a straight up vote.
Okay. All right. Seeing no further comments, all those in favor of the motion, say aye.
Aye.
Aye. Opposed?
No.
Passes 4-1.
Thanks very much.
Thank you.
Talk to the state.
All right. We did have.
I'll be talking to your constituents.
Come over to Springfield.
Your karma will kill you, I hope so. You have to know that
Once the room-
local code does not trump federal or international law. It's okay. You're going to cost a lot of money to the county. Again, karma, karma, karma.
Nope, an appeal.
Unethical, not on your face. This is white men. We got this. Look, the pretty
I'm a Jewish white man.
All right. We did have a few items that to go back and finish up on. And we'll go back to county administration announcements. I think Commissioner Lycan has a meeting in Salem. I don't know. You might be a little late, but drive safe.
Is that the caucus you're going to?
It's the joint transportation.
Oh, okay.
Yeah. All right.
All right. Mr. Mokahysky.
Thank you, Mr. Chair. Just a couple items. First, I was going to share with the board that I had the opportunity, as I told you last week, to meet with the Florence City Manager on Friday, and had a really good meeting there. We talked about a number of the items that you heard earlier here this afternoon. Revision Florence, and that's a discussion that on some level we likely will have with the board. Florence's efforts to make some investments in the Highway 126-101 corridor area. There's signage, wayfinding, and other landscaping and aesthetic improvements, along with the ODOT reconstruction of that area. So they're doing a nice job partnering with ODOT to try to reduce the overall costs there. They are seeking some county participation in that effort, and so that's a conversation that we'll bring forward at some point in the future. We talked about connecting the Harbor Vista Park to city sewer. So that's something that we're working with the city of Florence on. We talked about the park master plan in Ocean Woods, and you saw both of those county properties referenced in the earlier discussion, as well as the Siuslaw Estuary Partnership. So a lot of good things happening in Florence, and I just wanted to report that to you. We also last week had the kickoff of our Parks Master Plan Task Force. If you recall, a little over a year ago when we began the restart of the Parks Master Plan process, we proposed the creation of a citizen task force. We put that out to residents throughout Lane County to apply, and we last week kicked that effort off. I believe something in the range of 25 residents from throughout Lane County, geographic distribution from Florence to Oak Ridge and up the McKenzie. A really great turnout there. The mayor of Oak Ridge was one of the individuals who's serving on that task force, along with a number of other folks. And so we look forward to that effort, and really, again, trying to expand the public participation in our Park Master Plan update. Third item, I just wanted to remind the board, I'm going to attend. I understand there's some commissioners on Friday that are planning to attend the regional meeting on public health modernization that'll be held in Albany most of the day on Friday, so we can provide an update at the next meeting on that. And then two upcoming items. One, next Tuesday, December 20th from 11:30 a.m. to 5:30 p.m. We're going to be having an open house in county administration to welcome anyone who's available and interested, a holiday open house, just to thank everyone for the great work over the past year. So invite commissioners and anyone else who's available to stop by our offices next Tuesday, December 20th from 11:30 a.m. to 5:30. It's just a drop-in opportunity to say thank you and for the great work for the past year. And then finally, the state of the county address. Commissioner Stewart may want to add more to this schedule for Monday, January 9th at 1 p.m. here in Harris Hall. So that's all I have right now, Mr. Chairman, unless you have questions.
1 p.m. or 10?
That is 1 p.m. Yeah,
okay.
1 p.m. Monday.
I've been telling
That's
people
good.
the wrong
We kind of
time.
need you to show up, Mr. Chair. 1 p.m. Monday, January 9th here in Harris Hall.
Okay. Any comments or questions? All right. So we'll move down to commissioners' business announcements from the commissioners. Commissioner Farr?
No, that's fine.
Okay, no announcements. Then I'll move to agenda team requests, work sessions, anything from the commission? Mr. Farr?
Thank you. Mr. Mokahysky, maybe you can help me with this one a little bit. We had some testimony this morning regarding the possibility of an ordinance or the possibility of an executive order or an administrative order. Can you give me a suggestion as to how we might move forward with that?
Sure, Mr. Chair, Commissioner, we, as we've talked a little bit about, and there have been these discussions, and I think at the City Council, Eugene City Council meeting last night, they had over 50 people that testified on this issue. So there are some discussions happening at the city, and we've seen some email discussions about similar requests. And one of the things that we've talked about is the difference really between cities and counties. And one of the significant differences is that in counties we have a number of independently elected department heads, including the sheriff and the district attorney and the assessor. And the board really doesn't have authority to direct the operations of those independently elected offices. You can allocate the resources for those operations, but you can't direct the day-to-day operations. And so that's a dynamic that doesn't exist in city governments. So listening to the testimony this morning, I think, you know, with an eye towards trying to hear where the concerns are, but also the constraints that we have here, you know, I think that it's worthy for us to maybe explore what would be possible to look at existing state laws. There's a reference to ORS, both the deportation, the laws that reference deportation, and the laws that reference registries. And so what I'd like to do, Mr. Chair and Commissioner, is look into that, and potentially we could look at, if the board would support this effort, an administrative procedural manual that would reiterate the existing state law that exists there and reinforce that, just like we have done with our statement of unity pieces that reinforce that for all of our employees. It's my understanding that a similar approach is may have been taken at the City of Eugene, where the city manager has put forward an administrative policy that reinforces that. So I think that that's something that we could look at. I would encourage some conversations with the sheriff and the DA to see what the impacts of that would be, to make sure that whatever we do doesn't cause unintended consequences or challenges from an operational standpoint. Okay. But if you'd like, I'm happy to look into that and then have some of those conversations along with you, Commissioner Farr, and anyone else who's interested, and bring that back to the board on any proposed actions that we may take.
Okay, and that'll be sometime after the first of the year. Okay.
Right.
Do you need heads on that, or can you operate on that just on your own?
I'm happy to look into that, and you know, the administrator makes changes to the administrative procedural manual, but I think given the comments that you've received from the public, happy to bring that back before we would enact anything, to get feedback from the board on that.
Okay, and unless I hear opposition, just you and I can kind of coordinate that and let me know how things are moving, and then I can bring it up potentially as a agenda item request after the first of the year for follow through on that. Does that seem reasonable?
I think certainly is, and you know, and I would move forward with the understanding that anything that we would do would be consistent with existing state law. Mm-hmm. So I will welcome the board's feedback on that.
Okay, then I guess that's all we need. Thank you.
I think, me personally, at a minimum, it's important to know the law. So when people are asking you questions, or, you know, we can state the laws that exist, and that's what we're going to uphold, as where you took the oath to do. So I think that's important. I just kind of caution. It seems like we get in. We've taken a step further than anybody's taken, quite frankly, with our statement of unity and the support that we've received, our resolution of adoption. I don't know of any county in the research that's taken the leadership role and done what it's done. And, you know, then, you know, I just hate to see us diminish those results by going down a road of an ordinance or something like that, you know, we've done this with NDAA, with multiple other items, that it seems like, you know, for some groups of people, they want more, and then it ends up, you know, being something that gets very difficult, challenging, and ends up not producing the results. So I just want to make sure that whatever we do, we're not diminishing the great work that we've already done. So,
and I don't think what you prescribed moves us in that direction. So, okay. Thanks.
Any other conversations? No. Okay. Then we'll go. We don't have an executive session. What about review of assignments? I'm sure that's one of the items.
Mr. Chair, that discussion we just had there in terms of analyzing the state law and having conversations with our elected officials about a potential administrative policy reinforcement of state law. And then the other one was the, of course, the last item that you just discussed, and the report back from staff February 12th? Sorry, I missed the date. February 12th for the fourth reading.
I don't recall the date.
You picked
February 12th.
February. Yeah, we'll have that on
It
the
was
record.
February 14th,
February 14th. Thank you for the
St.
fourth reading.
Valentine's Day.
With the additional information requested, there was one other item then, under item 7B, the discussion that we had relating to Housing First, supportive housing, and particularly for the fairgrounds. There were some questions brought up that you requested follow-up on about particularly the resources used to purchase that property. And so I believe we'll have answers to those questions at the joint meeting with the Fair Board tomorrow.
Oh, tomorrow. Okay.
Yeah, so we should have answers on that, but we'll add that to the assignment list.
Okay. Well, as I stated, there's no executive session. Other business, I just remind the board that tomorrow we're once again at 9 o'clock, our Fair Board meeting, joint Fair Board meeting. We also have a discussion about the city-county partnership, and any updated information there. And then at 2:30, we will convene downstairs here in the Harris Hall to interview 3 prospective candidates for recommendation to replace Senator Edwards for House or Senate seat 7. Is that correct? So with that, we're adjourned for today.